Good evening, good to have you with us at the 8 p.m. edition of the Urban Debate. Tonight we put the spotlight on something that's extremely important to all of us, which is our personal data. In this digital age, in the age where our maximum interaction is with our cellular phones and our various electronic devices, our laptops, the most important thing for us is protecting our data, protecting our information. And for long now, we have discussed how there is a dire need in this country to have a personal data protection law, a law that safeguards your and my privacy, a law that protects us and gives us ways for legal recourse, makes institutions, governments, private bodies, social media platforms accountable if there is a breach of your privacy or mine, if there is misuse of your data, if it is even used without your consent. A law much needed in our country. A law and a draft bill, actually, that was brought into the parliament a long time back, almost 2 years back. And then it was sent to a joint parliamentary committee for a deeper scrutiny, as it should be for most legislations. So crucial legislations, there needs to be exhaustive discussion, debate, deliberation, special committees who look into it, parliamentary panels, stakeholders' involvement, exhaustive conversations on the floor of the House, and so on before it actually becomes a law. And now we are looking at a situation where the Joint Parliamentary Panel has approved it, sent its set of recommendations. And that will now be part of the bill. But the opposition party members, 6-7 of them, have actually objected, have given dissent notes, have raised issues to say even though the Joint Parliamentary Panel has adopted these rules, we have serious objections to it. And they've made it very clear. So tonight, we're going to talk about what is it that we know so far about this draft bill, and what is it that are seemingly problematic areas, or is it just that the opposition parties are raising a hue and cry. We're going to tell you what we know of this draft, what has been reported so far. Of course, the details will only be made officially public once it becomes a law. But we will tell you what are the problems that many of these parliamentarians have now raised. Essentially, this law will talk about when can your personal data be accessed, by whom, under what conditions. Where is the consent required for your data to be utilized? Where should the data be stored? In our country, that's been one of the government's long-standing views. Data localization such that you have control, legal authority to deal with platforms who are storing that data. So accountability of the social media platforms, accountability of anybody who abuses your data. All of this, of course, started with the Supreme Court's order on right to privacy. And we're going to talk a little bit more about that as well. But let me tell you, what's the problematic part here basis what the opposition is raising? The opposition says that the exemptions that are being given to government agencies is too wide and is dangerous. That to say that a government agency can be exempted from this law for reasons of national security, public order, friendly relations with foreign states, that's extremely problematic. They also say that the conditions in which the data can be accessed is also very wide and sometimes a little vague. And so this is problematic. So let's debate this. Let's talk about what should be there, what is good, and what could get problematic. Deshratan Nigam, advocate of the Supreme Court, joins me this evening. N.S. Napinai, advocate of the Supreme Court and cyber law expert. Professor Om Prakash Mishra, spokesperson for TMC. Swati Singh Malik of the Congress Party. Dr. Prashant Mali, author for cyber and a privacy lawyer, also joining me this evening. And before we start this conversation, I must say that where we are headed is obviously a debate over when can you access people's personal data under the pretext of national security, sovereignty, law and order, and to what extent? And to what extent, beyond which you say, no, public order can't be a reason for you to unabashedly just read and access everything that I have on my phone or on my devices. NS Napinai, let's begin with you. To your mind, what would be the two key things to watch out for in this bill?
Tanvi, the first thing from my end is I will be very glad if the bill actually comes out and becomes law.
Oh, absolutely.
Because good, bad, or ugly, we have waited for this law way too long. So we need it. How far is it going to meet our requirements as users, in terms of individual privacy? Even 20% is more than what we already have. So if you look at what is in public domain, whatever seems to come out from that is that the proposed additions from the JPC's recommendations appear to indicate that the screws will be tightened on big tech. There is going to be a lot more accountability from them, and the consent framework that was originally envisaged as the primary basis for data protection is likely to be given fillip, because if you look at today's reports, it indicates that even with respect to third-party transfers, there has to be specificity with respect to consent. So a lot of it in terms of big tech and how they are going to use our data may be the positives. Once this becomes act, the bill becomes an act, the other big positive is what we don't have under the current regime, which is that minimal two provisions under the Information Technology Act, 43A and 72A, they cover body corporates. Whereas this bill will bring the government into the picture, and there is going to be accountability from them. The issues or the problems that arise, however, in which some of the dissenting notes indicate is because of the exemptions that have been given for government agencies in terms of usage or even third-party transfer or access. Now, that aspect of it, all that I can say is the law, what it should be, what is privacy and the rights that we have, how should that privacy be protected, and what can a law be made for and how are all set out in the two Puttaswamy judgments. The second one clearly sets out the three parameters, which is that you must have a parliament enacted law for a legitimate state aim, and it should not be disproportionate. So if there is lack of proportionality with respect, sorry, this is the Delhi pollution getting to me. If you want proportionality, then the very basis of proportionality is, one, you can't delegate lawmaking to executive. That still has to form part of the main law. Two, you can't have very broad-based, rights. And the Supreme Court, again, has very clearly recently clarified that you can't, in the Pegasus case, that you can't just say national security and do away with privacy, right? So therefore, whatever the government comes out with finally, they have to keep in mind the lessons learned and apply it so that we are not going to get into a spate of litigations again. It's already delayed. Even under the proposed bill, it looks like we are looking at a 24-month window. There is this one amazing addition, which I must point out. I think I did the spoiler alert on Mirror Now only. I said that it is likely to be data protection and not just personal data protection. Yes. And that prediction has come true. And that's actually a phenomenal move, because India may land up being the first nation to regulate non-personal data. And that's why I said it is definitely tightening the regulatory framework for big tech. So a lot to look forward to. Yes. And it could be good, bad, or whatever, but it's still progress. It's still a move forward.
Yes, repeated extensions actually this parliamentary panel itself took. And with every parliament session, they got another extension to look into this. So at least they have crossed that barrier and gotten into the parliament, and the conversation will happen here. What is it that we want? Essentially, we want to strengthen our right to privacy and to safeguard our privacy more. We want, clearer, sharper, wider legal remedies to be defined. Like N.S. Napinai was saying, beyond what the Information Technology Act currently has, we need more a stronger law to complement that and to add to it. And then to define under what circumstances can access be given, where consent is required for big tech companies, where for the government the consent may or may not be required, under what circumstances can government agencies access our data. To the point of non-personal data, N.S. Napina, I will come back to you because that's one of the key issues that I wanted to highlight and explain to our viewers. But let me bring in Mr. Deshratan Nigam, because Mr. Nigam, even in the Supreme Court's judgment on right to privacy, while it upheld privacy as a fundamental right for us, even in that order, the Supreme Court had said that, of course, there will be exceptions under which the government should be and government agencies should be able to access your data, where this will not stand when it comes to safeguarding national interests, national security. But Supreme Court itself has also warned of not making that too generic, saying you must get specific, you must justify, you must put it in writing as to why you feel this argument holds true in every case. How will we balance that? That has to be the biggest point to look at when this law comes through.
Tanvi, in fact, this is still a bill and is yet to be debated and refined, I would say, or not refined. And then when the act is made, the rules follow. And the rules are framed by the executive and put in both the houses of parliament for 14 days. So that process is still to come because a lot of things are clarified in rules itself. So it is too premature to, come to any kind of a conclusion as of right now. But the fact remains, when certain people have raised objections, 5 or 6 people, although it has been adopted, and I have not seen the adopted bill. But the fact remains that these objections, when you look at the reasonable restrictions in Article 19, Clause 2, and these exemptions are almost similar to that. Those reasonable restrictions to your fundamental right to freedom of speech. And therefore, being similar to that, and those restrictions have been upheld by the courts. So I don't think there is anything much to be said about here because it is kind of a cut, copy, paste from there, those reasonable restrictions. And that is where the government agencies are seeking exemptions out here. But it has to be recorded in writing, and that would be open to judicial review. All the government actions are open to judicial review, and that's the best part of our constitutional system. However, so far as private bodies are concerned, the only option left for the people out here is that you go for compensation. If there is a regulatory system, there is an appellate system, then the finally appeal would lie to the Supreme Court if the act is made. However, the remedy available is compensation under 43A, if I'm not wrong, under the IT Act. However, the government agencies being amenable to writ jurisdiction, that's a very wide judicial review that these courts have. But the compensation is not an effective mechanism to deal with the private, fiduciary parties which are there who will be processing your data. That's a very important question. Can it be made in such a way that this data protection is in the field of public interest, so that writ jurisdiction becomes amenable to even the private companies? So because you need an effective legal mechanism for these big giants, and a parliamentary committee in India does not have much to, frankly telling you, so far as scrutiny and calling these people is concerned. Like a Senate committee in US, they can get, the heads of these giants company and, scrutinize and ask them all kinds of questions. But in India, they don't even come and appear. They will send a third level officer to appear before and then create all kinds of an issue.
Well, so I appreciate, Mr. Nigam, the fact that, a series of these meetings and conversations happen, because I would like to see our parliamentarians actually sincerely, diligently debate policies before they are made. So for me, it's very important when legislations go through this route, because at least there is conversation. Often on the floor of the parliament, there isn't, and you and I know this very well. On a side note though, Mr. Nigam, I have noted down the statement that you made that, even after it becomes a law and the parliament passes it, there is the recourse of going to the court. over any issue that we may have. Because often when you and I debate on issues, you say Parliament is supreme, and if the Parliament, which is elected by the people, has made these laws, then we must respect those laws and not necessarily have the courts intervene in everything. Just saying that on a lighter note, I have noted this down for the next time you and I have that argument.
That's a partial statement. You know, anything made by the Parliament has to be tested on the parameters of a constitution.
Yeah, of course.
The people of this country are supreme. Please let me clarify. I have never said Supreme Court or Parliament is supreme. People of this country are supreme. That is the basic. We, the people of India, that is at the center.
And we, the people of India, need stronger framework to protect our privacy. Now, let me just read out what one of the parliamentarians who submitted a dissent note, Manish Tiwari, has said in his note. And he says, this is a bill that seeks, therefore, to provide blanket exemptions either in perpetuity or even for a limited period to the state and its instrumentalities. And this is, you know, one of the biggest problems that he has with this law. He goes into, you know, extensive details of why he's holistically right now rejecting the draft in its current avatar. Where do you stand on this aspect, Dr. Prashant Mali? The aspect of saying, well, blanket permission to government to exempt its own agencies from this law.
We look at the law which is right now persisting in our country, that is the IT Act 2043A, also exempts government from the purview of Section 43A from following reasonable security practices. So because they have this precedence before them that they have been granted this blanket permission of not following the law, here not following the reasonable security practices, because the body corporate definition doesn't define government as body corporate. So they are taking this way out and again want government to get out of this DPA or PDPA, what it will be called as. But what I want to bring in focus is we have Aadhaar, we have e-governance mechanism where hell lot of private data of Indian citizens is present. And it is not holy cow, it's not government holding the whole data. Government has appointed agencies and vendors which are of dubious nature or which are of objectionable character. They are from countries which we really don't trust. So, or the softwares which they are implementing, they are not known for a great trust. And the database which they implement, which has investments of parties which we don't want to share data of. When this is a broad, IT infra of government of India, then why not bring in government? If you don't want to bring in pure government, bring in those agencies of government which holds sensitive personal data or personal data of citizens of India, which has private data as defined in Section 43A as of now, or as defined in the coming Personal Data Protection Act. So at least, if not the whole government, because there are so many issues there, national security, blah, blah, you can have these agencies which are delivering e-governance made part and parcel of Personal Data Protection Act. And until unless we do that, I don't think the right to privacy gets delivered to citizens of India. The right to privacy, which Honorable Supreme Court had given us as a fundamental right, holistically is given to citizens of India. And the whole idea of data protection will be debated. And I'm seeing this act seeing this bill being promulgated and making, in so many committees and discussions from 2006.
Yes.
This is the oldest debated bill till date. And it has not become a law with people are waiting till date. If it becomes a law also with such kind of, protection to government of India, with the current government at dispensation, which constantly gets debated on any law, whichever it makes, I think this will be another law which will be debated and which will be, food for thought to many intellectuals, and aspirations would be counted on this law also.
No, it's fair enough. Politicians will always play politics, and people who want to see, even actual facts in certain laws in a specific light will continue to do that. But it is our job to, bring in a host of experts to try and break down what we know so far. And I again will emphasize what first two panelists emphasized, that even right now it's in initial stages. Even if it's a step closer, it's not the final law. But what we know, we must debate, because if it's problematic, it can be changed, corrected at this point. Once it becomes a law, and then to cry foul about it, for me also will be too late. We will continue to do that, as some people did as far as the farm laws are concerned. But let me bring in Swati Singh. Swati Singh, for months together, this law was debated by the parliamentarians, and yet everybody couldn't come on board. Why is that?
Tanvi, it's very obvious that especially this clause 35, which gives a freeway to the government. I call it the freeway, and they're trying to bring it in at the time of where there is already a huge trust deficit between the people and the government. As it is, we have seen instances, we have been witnessing, be it UAPA and so many various other instances where the government, and in fact, this is for that matter, where the government has been, as it is, spying is the word. And they use these laws to settle, to go, after individuals, to go against people who are raising their voices against the government. Anybody who challenges or questions the government is trying to, somehow brought into the ring and taken to task. When we are living under that fear in this country right now. And that time to give the government a power which is unquestionable, and the kind of freeway that they're giving. If they are so concerned about the national security, which is a genuine concern, then they should also bring out a framework where some sort of a permission can be taken from court. Why can't they go to the authority which they are appointing under this act and seek permission for the exemption, seek exemption? Why does it have to be an exemption without any sort of supervision, without any sort of, there's nobody to question the supervision. So this is the major, lack in this act. Of course, there are various other factors. There are, this law seems to be only against the private sector, whereas government is completely, given freeway. And whereas we all, as students of law and being lawyers, we are taught fundamental rights are against the government. Right? And here I cannot press my fundamental right against the government because of this protection, this blanket protection that the Act itself is giving them. Of course, there is reasonable restrictions. Of course, all those grounds are also there, but those have to be decided by somebody. It can't be left at some officer. And we all know how these central, these authorities work, be it NIA, be it CBI, whichever these authorities are, we all know how it works. It's very, it sounds very good. And to say that these are independent investigation agencies, but we all know in the practical world how they are being used by the central government, how they are for that matter influenced by the central government,
how they've always been, not just now.
Well, there's always been interference. And, that sort of supervision, I would say. Earlier there was supervision, now there is influence. Right?
Swati Singh Malik, let's be realistic. I agree with your point, because the larger idea would be to say no government, current or past or future, at state or central level. Here also the states get the power, by the way, as well. So should have that kind of power where there is no explanation sought from them. So should there be a method of seeking court permission? Yes. Professor Om Prakash Mishra, where do you stand on this debate? There is an argument of sovereignty, national security, and obviously you can't have the government explain details and intricacies of national security at the drop of the hat to everyone. You're on mute. You'll have to unmute yourself, Professor Mishra.
Hello?
Yes, we can hear you now.
Sorry about that. I read the bill. And in fact, I have been following the debate that especially your program has been raging past 2-3 years. And that way I would like to compliment Miran now. Tanvi, you will recall that the union government contended before the Supreme Court that the right to privacy has not been provided for specifically. And so therefore, by implication, they wanted to suggest that it doesn't exist. Of course, Supreme Court rejected. You will also recall that around the world, especially you may say the 21st century, people, society, citizens groups, everywhere, they are fighting the inroad into their freedom from a very omniscient, omnipresent government. And the government's ambit from the standpoint of welfare, if it gets expanded, that is welcome. But when it gets expanded in terms of intrusion, then that is a matter of great concern. Two members of parliament belonging to my political party, Derek O'Brien and Mohua Moitro, they have jointly written a note of dissent. And then I would also like to acknowledge someone erudite and versatile, in my view, understanding, Mr. Jairam Ramesh. He has also dissented. Now, what is at stake here? The objective of the bill, as I read the draft bill, of course, it is at present, that is to protect the privacy. I would like to argue it is going to do just the opposite. And why I'm saying so, that it is just not about the type of control that we should have over the social media side. It is actually about the type of freedom that we can have from a government which is basing itself or basking under the glory of being a surveillance-centered government. And this is what is happening. Third point that I would like to mention is that some of the greatest breaches to the data has taken place here in this country. Not only the Aadhaar card details or the bank frauds, these are all on the rise. Anything and everything almost with the government, unfortunately, of course, actually is going to the third parties and is actually also going to powers inimical, possibly to the national interest. So far as the national security is concerned, of course, that is an article of faith for all of us. But then Mr. Desratan Nigam, when he said that Article 19 also has reasonable restriction, he possibly is forgetting the fact that Article 19 is vis-a-vis the government. It imposes the limitations on the government. At the same time, it actually allows them a certain, contingency in terms of a grave situation. But here you have, as the Congress spokesperson very rightly pointed out, Section 35 that is giving blanket power exemptions to the government authorities. So therefore, again, coming back to Mr. Desratan Nigam, and this is of course in a lighter vein, you were referring to his views about parliament being sovereign, etc., etc. Maybe that is how he is looking at it now. But after 2024, when BJP possibly and hopefully would not be in power, and then he is actually going to argue the way that he has argued today. So sum and substance of my perspective and perspective of my party is that this bill is being rushed through. Of course, in 2019, but not many.
But Professor Mishra, I mean, I can understand if you say there are valid concerns, but can we say it's being rushed through? We're already extremely behind schedule. The Joint Parliamentary Panel has been sitting on this bill now for 2 years.
No, but apparently that is right because it's 2018, 2019. But then in between, there was not many meetings. I have had discussions with people that I know and who have been involved, and they have pointed out very few meetings. The chairman of the committee, he himself actually introduced 170 amendments. And then you say that, of course, it is JPC, the BJP enjoys brute majority. You see the dissenting note that has been given by 7 members. This is very important, and in fact, I find that there is a commonality in this, that they do not want to weaken the government. They would rather like to have the government strengthened in terms of its core functionality. But then the exemptions and the type of blanket exemptions that has been given is actually liable to be misused. And unfortunately, and I will again agree with the Congress spokesperson here, that is what is happening in this country.
Okay.
And we are also very much afraid because of the type of gigantic power that the government has assumed. Can you believe that the entire parliament session had to be wasted, so to speak, if you would like to call it that? All of us protesting, just only wanting to know from government of the day that whether they have bought the Pegasus or not. And still they could not answer the question, neither to the Supreme Court.
Okay.
So this type
Okay.
of
So you are also
is
making
very
the point
dangerous.
of trust deficit in the light of recent events and controversies that have happened, including Pegasus. Fair enough. We come back to the contentious section 35, Mr. Deshratan Nigam. The section 35 that allows a government to exempt government agencies, from if this becomes a law, which already also exists right now. But does that mean it should happen in future as well? Can we not have a written clause that says you need to explain yourself, justify this to a court, and then you proceed?
Let us be very clear, there is a theory of separation of powers under which we operate under the Constitution. If for every action the executive goes to the Supreme Court for taking permission, what about that theory of separation of powers? The Supreme Court tells you for every step the government wants to take, not even in this law, there can be various other laws. You say that government has to take permission. Government takes action, it has to justify its action, and if it is not able to justify, you have a course to judicial review. This is how our constitution works. Courts don't give permission to the central government whether you can take this particular action or not. That's not the way our constitution is made. That's not the way our democracy functions, whether it is a TMC government in West Bengal or the Congress government in Rajasthan or in Maharashtra. If that
Or
starts
a BJP
happening...
government elsewhere.
No. Please don't
Or a
interrupt
BJP
me.
government elsewhere.
Mr.
You are referring to
Mali,
only the opposition ruled government. It will apply to all the governments, including BJP ruled government.
So that's what I'm saying. Any
But you only
government.
mentioned
Okay, yes. No, Professor Mishra, of course that is. But since we are constantly saying, oh, the problem is because there's a BJP government and the BJP government is going to misuse it,
No,
I think it's also going to, it has to be highlighted that it's all political party governments. Yes, but go ahead, Mr. Nigam.
So therefore, I mean, courts are not there to give permission to the government whether to act or not to act. They are there to finally exercise their right to judicial review. And that is how it functions. It's not a dictatorship by any court. So one has to be very, very clear about the theory of separation of powers, where the people have given mandate to their elected representatives to formulate a law. That is why it was pointed out by one of my co-panelists that it has to be a law made by a parliament, not left to the executive.
Yes.
So these theory of separation of powers are very, very important, and established law is that let parliament make its law. It will be tested on certain
so you're saying, so you're saying, and now this is not about the law, making the law itself, but it is to say that if the government is going to tomorrow exempt CBI or NIA from looking into the accounts of all of us on this panel, should the government or NIA have to go to court to say, okay, we are going to give this exemption because this is what we are investigating and this is what we need?
No, certainly not.
Okay, so you say not?
Anybody feeling aggrieved of that can go to the court that this is not a reasonable order, this does not certify
but
certain
people wouldn't
parameters
know.
of law. No, people can know. Order to be recorded in writing. Please remember, orders, reasonable reasons have to be given for such kind of an exemption. Please remember that.
That will only be if you actually do arrest me and start prosecuting me and you present your case and that evidence. How else will I know that you've put me under surveillance?
No, this is data protection I'm talking about.
Yes.
You're mixing many things. Let us be very clear about data protection.
Yes.
We are discussing data protection.
And if the government wants to exempt an investigative agency from accessing my personal data, will I know?
See, the fact is, no. We are still not clear. There has to be rules still have to come out.
Right.
So the rules, we have to still wait for it, what kind of a total framework which is going to come out. So we cannot jump the gun as of now. But taking court permission, I mean, I cannot even imagine in my wildest imagination that the courts give permission for the government to act or not to act.
Okay, so you said it shouldn't be. The issue that has been raised by the opposition MPs as part of their dissent does say that one of the widely debated clauses in the panel meetings where the members had argued that public order should be removed as a ground for exemption. They also pressed for judicial or parliamentary oversight for granting such exemptions. So that's one of the key things that we saw massive disagreement during these meetings.
Let me add here.
Yes.
What they are saying that these reasons to be given in writing should be placed before Parliament
or court.
No. See, court, I certainly don't agree, but that can be debated upon, like the rules when are framed under an act. Then they are placed in Parliament for 14 days. Generally, no discussion takes place on that, and they are deemed as passed.
Okay. N.S. Napin, I wanted to come in on this contentious point. Yes.
Yeah, sorry, Tanvi, I was literally jumping up and down because I wanted to just prevail on this aspect too. I think substantially Mr. Nigam has covered what I wanted to say, but I just wanted to clarify this point of distinction which I think got missed out. We can't forget that law enforcement is different from data protection.
Yeah.
We can't forget that governance is different from data protection. So today, if you're applying for a license, can you then say, I will refuse my consent for data, but you still have to provide the license? From your side, on governance. From the governance perspective, when they are exercising their right as a governing body, can they say that I have collected it because I'm the only authority which can issue you a driving license, but tomorrow I will then convert myself into a commercial entity and then sell your data? And for that, if I take exemptions under 35, that is what will be inappropriate.
Okay.
That is what will be disproportionate and excessive. We should not lose track of the fact that law enforcement surveillance also is permissible provided checks and balances are in place, and those checks and balances are in place through a parliament enacted law and are implemented. So that is the distinction which I had mentioned earlier and I wanted to bring out. And I'm totally with Mr. Nigam when he says you can't convert courts into a permission authority because that's not their role. Their role is of a reviewer. So when you're talking about court permissions, firstly, you don't need Parliament to enact a law with respect to which court will have rights. They can, of course, take away and vest it in some other alternate authority, but there are certain inherent powers of High Courts and Supreme Court which you cannot take away. So therefore, that is something you can do irrespective, but that cannot be made into a supervisory role. So we should not start again making it disproportionate, even in terms of governance when we look at it from both sides. We are not really talking about paranoia here, we are talking about protection.
Yeah.
That's what I wanted. And there, on that note, I also wanted to intervene on this point that it is completely incorrect to interpret Section 43A to say it exempts government. It is silent on whether government is covered or not because it only talks about covering body corporates. So when a provision provides only for a law or regulation for a particular kind of entity, that's what it tries to regulate. And now the advantage you have with the proposed data protection law is that it is going to govern governments also. When we are talking about 35, we are not for a moment saying that government agencies will not be covered under the Act with respect to collection or processing or utilization of data in the manner in which it is provided for in the law. It doesn't traverse into law enforcement or governance aspects. It may in certain circumstances. And my only concern with 35 is you can't leave it open-ended for you to decide as and when you want, what is it that you will add. Whatever it is today, run it through Parliament. Let that be the law, and the rules should only be for implementing it. Executive cannot create the law in terms of exemptions, etc.
Okay. So now that you've heard the two experts, let me come back to Swati Singh Malik on it to say that it's not possible, as Mr. Nigam is saying, to go back to the Parliament or court every single time.
I really respect what Mr. Nigam has said, but nobody is stating that you run to court. What we are stating is the authority that you are looking to establish under this Act.
Yeah.
That authority at least can grant you that permission. Your permission or your right and my privacy, my right to privacy, Tanvi, your right to privacy, our Twitter data, our Facebook data, the authority cannot lie with an officer of these investigation agencies. It has to be a neutral, it has to be a third party. It has to be somebody's in supervisory role in the authority, appellate authority that they're looking to establish under this act. I'm not saying go to court. We are not saying we should run to court because courts are as it is overloaded. We know that judges are already working very hard, and with all those backlog of cases that we have. So I'm nobody suggesting that, but yes, if you are establishing an appellate authority, then that authority should have that. You should have to seek permission from there. There has to be some sort of a mechanism. Our democracy, again, our constitution, of course, Mr. Nigam being senior here, our constitution, of course, also works on checks and balances. Of course, there is separation of powers, but there is also checks and balances that we have to respect. None of these three have the complete authority just because there is separation of powers.
Okay, yes.
Can I just add one thing?
Yes.
The authority that one is being talking about in this particular bill is a redressal mechanism, not a permission-giving body.
Yes.
So let's maintain that distinction. Within an act, you don't have a permission-giving body.
Yeah, it's actually a grievance mechanism that has been set up.
It's a grievance mechanism, which is it does not give permission, and it should not give permission also.
Okay, and where also there are problems, by the way. Questions are being raised on the constitution of it, of who will be a part of this body itself, this panel itself, and whether the right people are going to be appointed. That's also been a contentious point as far as the Joint Parliamentary Committee itself is concerned. Now, we've debated and we've got, in my view, justifiably given a large percentage of our conversation to the government aspect of it. I also want to move ahead and talk a little bit about making private players accountable for misuse and abuse of our data, because that, as we also know, is happening at a widespread level. Professor Mishra, you wanted to make a point before we move to that?
Yes. The so-called distinction that this being data protection and law and order is separate, that actually may not be working. In fact, in today's world, increasingly, it is all about data.
Yes.
And so therefore, that type of an artificial distinction that could have been valid in 1980s or 1990s, increasingly not. Secondly, separation of power, checks and balances, we all do know. Mr. Nigam should know that this debate has actually ended with the doctrine of the basic structure of the Constitution and fundamental rights, and now the right to privacy, that is part of the basic structure of the Constitution. Parliament of India has actually not much of a leeway so far as changing or redoing the basic structure is concerned. And lastly, I would say that the opposition members or those dissenting members, they have given constructive suggestion. In fact, it would have been very good if their concerns could also have been written in, unless the government of India or parliamentary majority of the BJP, they want actually to impose it. So, of course, our two members of parliament, Derek O'Brien and Moa Moitro, they have reasonably argued. And when it comes to the parliament, we are going to put up our suggestions.
Yes.
I'm sure that the other opposition parties would also do the same.
Yes, and then we'll see, what debate happens there and what government has to say. Right now, the BJP isn't really talking about this this draft. The law minister, of course, has put across his viewpoint, but we would like to hear a lot more from the government. Let's come to the other part, and the other part is making the private players accountable. And let me ask Dr. Prashant Mali if he wants to come in there, Dr. Prashant Mali. In the light of the recent events of data leakage, use, abuse, selling it off to third-party members for all their purposes, what is required out of this law?
See, the accountability of the private parties holding sensitive personal data and personal data of Indian citizens were missed completely by any of the laws. Laws were there, but they were not enforceable. Now, let me make myself clear that this law specifically gives you two kinds of remedies. One is criminal remedy and other is civil remedy. Even if we have this law to be compared to international law, EU law called GDPR, but here we differ from them is in the criminal part. Here we are looking at specific jail term for the people who are handling data and who do not follow reasonable security practices and when the data gets leaked. So accountability about from private parties or IT organizations which hold data, Indian citizens' data, is going to be more, because there has to be some kind of deterrence in their mind, which was clearly absent because of the Section 43A implementation or non-implementation strictly, because there was no penal provisions there and not much fine to be deterred. But this law is going to really deter them from doing some kind of things. Like we had incidences where certain apps were leaking data year after year. So they had a track record of leaking huge amount of data. So that possibly could get arrested, and the data of individual citizens will have some recourse when this data protection regulator is being formed. I think the whole of debate was around the courts, but before the courts, there is going to be a regulator, and the regulator is going to regulate a lot of things, as we have learned from the Western regulation.
No, but let me ask you this: will the regulator be able to? And that's been long debated. We of course need more details. But data localization is part of this draft to ensure that all entities store their data here on servers in India such that they come under our legal framework is part of these laws. But will this regulatory body be able to make them accountable? If I go to them with a grievance of mine to say they have, without my consent, accessed XYZ personal data of mine and then sold it elsewhere, will it be this body that takes care of it?
Regulator is there to enforce the law as well as the rules being made gradually, because this law which has been right now been presented is not the final exact law, because there will be so many rules as we go further. So regulators' prime role would be to enforce these rules and to bring in the core philosophy of the law to be implemented. Like obviously the data localization would be one of the part if it gets enacted in the law itself. Second point, there is a provision of adjudication. Now, I have my doubts on the adjudication where, when the data is leaked of a common man and you go for recourse, you go for a remedy. Adjudication per se in our country when it comes to the IT Act has not shown good results. It has, because the IS officer, the executive was actually manning the adjudication post. If the same thing continues in the data protection bill, I have my doubts about it, because the experiment with the IT Act is being 21 years now. It's not shown good results in any of the states except for a few states like Maharashtra, Gujarat and Delhi. Other states have completely failed, Andhra Pradesh and some southern states. Other states have failed. So about hardening the adjudication in the data protection bill is very important to give justice to common man. The app users and the e-commerce users, if we need to give them justice, the adjudication mechanism in this should be differently worked out. And why not have an online dispute resolution? Why not be talking about handling the grievance online when it is, talking about IT infrastructure and data, which is per se from the cyberspace itself. So I think online dispute resolution gets completely missed in this law, which should have been bought, and we could have been seen as forward-looking than the Western laws in place. That's my take on this.
Okay. Let's come to the other big aspect before in this debate, and that's N.S. Nappanai, what you raised earlier about the fact this isn't just about personal data, it's a data protection bill. What's the non-personal data that we are seeking to define a regulation for?
The non-personal data is that which does not identify the individual, right? For instance, your Google Maps works on that. And the real crux of this and why it becomes relevant when we speak about big tech is, this is where the real money is. And when government, until now, all nations have actually shied away from regulating non-personal data. The only regulatory mechanism you have so far is of the European Union coming in to say that there should be free flow of non-personal data. That's it, no restrictions, nothing else. Today, when the government is looking at non-personal data, on one hand, it brings in all the suggestions from the non-personal data reports, the 2 reports that came out, including in terms of disclosures on the algorithms, in support for startups, sandboxes, etc., and also in terms of possible sharing of data. Now, what I see as a problem here is there will be a lot of dissent because of proprietary rights that will be involved with respect to processing of non-personal data. So whilst general data, raw data may be considered as a common source, processed data is proprietary. The mode and manner of processing is also proprietary. So we already have laws which decide on how that proprietary legal framework and protections will work. You can't now dilute that process on the assumption that you are then supporting Make in India or local startups. So that balance in terms of the proprietary rights, again, proportionality is likely to come in. Now, all of these, I'm saying, when you look at the 2019 Act itself, that was there under Section 91. And it's just looking like it has been elaborated upon. There are some good aspects of it. You raised the issue of data breaches, Tanvi. The proposed Data Protection Act looks like it may ensure or insist upon reporting of not just breaches of personal data, but also of non-personal data. So that's going to be a big leap, and it's much needed. And this mandatory reporting mechanism forms part of the current legal dispensation. Again, it has been a real issue in terms of its implementation. So how far the proposed additions are likely to be implemented, and what will be, again, Parliament enacted checks and balances, Parliament enacted penalties. And that's something very critical. And I do hope that either before it's tabled before Parliament or in parliamentary debates, this aspect of ensuring that anything that needs specificity, everything that is penal, will be set out in the Parent Act and cannot be left to rules and regulations.
Okay, thank you so much for really explaining that, first of all, the gravity and the significance of that aspect. I am a little short on time, but yes, Mr. Nigam, quickly.
See, as I already touched upon it at the initial stage, how to regulate these private bodies.
Yeah.
Now, if you define data protection as a public function, please define it like that. This would be amenable to writ jurisdiction. The moment you say it's a public function, and even if you're a private party, then it can be amenable to writ jurisdiction. That's a very effective remedy. And obviously, there is also another Section 66 in the IT Act, which is a penal provision which generally people don't point out for dishonestly and fraudulently misusing the computer source or the data stored therein, because it covers the offenses given in 43, Section 43. So 66 is the penal provision which is already there, and 43A deals with the compensation. So if you look at the overall scenario, 66 is a very stringent provision, where you have three years imprisonment and fine up to 5 lakh rupees. That can be amended for this particular act. Okay. If internet giants are there.
Okay, fair enough. Completely out of time. I'm going to thank all of the panelists for joining us in what will be, beginning of many more such conversations. If this bill comes to the floor of the Parliament this winter session, I don't know if it will actually become a law by this session itself. Maybe not, since the opposition has already upped its game, upped the ante on this specific law. Since a big debate about privacy, right to privacy, intrusion and surveillance is such a big issue right now, a hot topic right now in our country, it's very difficult to imagine that the bill will go through in the first run. But what we would like to see is healthy, exhaustive, extensive discussion into various aspects. What we would like to see is not parliamentarians telling us that they didn't get enough time to debate it and it's being rushed, but them taking out the time to debate this, them showing us that it is actually important because they care for people's privacy, for our data, and for protecting our data, and not just for their politics. That will be important. Thank you so much for joining us.